Peace and love, everyone. Prince out with More Simple Light Trust Corps, based out of Miami State Territory of Florida, within the continental landmass of North America, right? Coming to you with a brief tutorial, part 1 of 5 in a law research series, all right? This information is compiled for informational and educational purposes only. This is not legal advice. If you need legal advice, by all means, get yourself a lawyer, and that's competent to handle and specialize in your particular matter. All right. I am going to be showing a little review of the My Attorney software, which I personally enjoy. You get to set up a number of different profiles. This is a public service advisement account. So I'll be using this account just to show some of the tools of this software, which you can get at Office Depot in the computer software section, or you can even shop for it online at Amazon.com. You can look for an Amazon affiliates link in the description bar below, and by all means, make your own decision. It's great for managing and planning estates, managing living wills, trusts, financial documents, business. Once again, My Attorney, home and business. We'll get into that later. All right. Let's go ahead and jump into this brief law research series 1 of 5, Truth in Lending Act. So that way you can go ahead and get into your own review and research for yourself. All right. Not everyone's got a 30-minute attention span. Not everybody. Okay. So let's do this. Independent Study Law Administration Medicine Research Series, Part 1, Truth in Lending Act. We will be going over in the future the Fair Credit Reporting Act, FCRA, the Fair Debt Collection Practices Act, the FDCPA, Criminal Taxes and Criminal Tax Handbook, and we'll also be doing some research on the Medical Patients Bill of Rights, also known as the Affordable Care Act. All right. So in the future, you can also look for the petition preparation series, in which we'll be going over the various petition forms for any of the 50 states under the jurisdiction of the United States. All right. We'll also be using My Attorney home and business software to prepare petitions for estate planning, living wills, powers of attorney, living trust, and in certain circumstances, the administration of estates. We'll also be going over preparation for petitions regarding tax preparation for individuals self-employed in the states, credit dispute affidavits, and bankruptcy petitions. Let's go ahead and get into this. I've already opened up a number of different websites, and just want to provide you this compilation or compiled series of information that you can use also in the description bar to, gain greater insights for yourself. And your circumstances may be different. They may be unique. I don't know what's going on in your life. Nobody else knows what's going on in your life. The law is the law, all right? But it is the standard for, seeking remedy regarding your particular issue. So in that instance, it has an element of abstract science or metaphysics, in which case, it's a theory of relativity. The law is basically a theory of relativity. And you have to, engage in your self-representing, if you are representing yourself, you deal with your matter, or hire an attorney if you're not competent to do it yourself. All right. Truth in Lending Act. If you need to view some of these websites, once again, they will be in the description bar below. Don't forget to like, share, comment, or subscribe if you've been enjoying any of the content that More Simple Light Trust Corps has been presenting and creating as often as possible, okay? Common violations may take the form of contradicting actions committed by the individual or the corporation seeking to file or defending against a suit in federal court. All right, conditions for filing complaints for violation: name the portions of the Truth in Lending Act that pertain to your case. More than one may apply. Relief sought: well, there is a link that we will be reviewing very briefly on that, and you can also check that out for yourself. And you'll also be able to check out the maximum damages available to you under the Truth in Lending Act. All right. Also, you'll be able to review the various laws that pertain to, or the relief for damages pertaining to foreclosure actions, all right, or foreclosure proceedings. Now, I'm not a lawyer. Once again, this is not legal advice. This is research assistance for the preparation of petitions to be filed within whatever jurisdiction that you need to. In some instances, we don't know where to start. Sometimes we're not fully disclosed the information in the contract, and you may need to review the actual contract in order to know what's going on or what kind of charges may be held against you, all right? So you can utilize the Freedom of Information Act, Title 5, United States Code of Law, subchapter 552, as amended by Public Law number 110-TAC 175, 121, Statute 22524. Below is the full text of the Freedom of Information Act in a form showing all amendments to the statute made by the Openness Promotes Effectiveness in our National Government Act of 2007. All newly enacted provisions are in boldface type. Subchapter 552, Public Information Agency Rules, Opinions, Orders, Records, and Proceedings. Subsection A, each agency shall make available to the public information as follows. Each agency shall separately state and currently publish in the Federal Register for the guidance of the public: A, description of its central and field organization and the established places at which the employees, and in the case of uninformed service, the members from whom, and the methods whereby the public may obtain information, make submittals or requests or obtain decisions. All right. So this is a request form, a request of information, right? Sometimes the best way to initiate a conversation with an agency or an individual that is in operation of a corporation may be to file it under the Freedom of Information Act if their information is not readily available to you within the Federal Registry. And as you've already seen, it must be updated. Subsection B, statements of the general course and method by which its functions are channeled and determined, including the nature and requirements of all formal and informal procedures available. Rules, subsection C, rules of procedure, descriptions of forms available or the places at which forms may be obtained, and instructions as to the scope and contents of all papers, reports, or examinations. Subsection D, substantive rules of general applicability adopted as authorized by law and statement of general policy or interpretations of general applicability formulated and adopted by the agency. And subsection E, each amendment, revision, or repeal of the foregoing, except to the extent that a person has actual and timely notice of the terms thereof, a person may not in any manner be required to resort to or be adversely affected by, meaning you can't be sued by, a matter required to be published in the Federal Register and not so published. So if the information is not readily available for you to challenge or dispute the accuracy or the information contained within a certain document that's been sent to you, or like the manner in which those documents are handled and filed and stored and used in contractual disputes, well then, Freedom of Information Act, 5 U.S.C., subchapter 552, is your initiating remedy. All right. Now you can go ahead and continue to review this chapter on your own, but if you're into, learning very quickly, you begin to understand that the preface or the preface of any or the preamble of any document essentially outlines the contents of the remaining portions. All right. Now, there are 18 pages in this document. It might take you 30 minutes to read 18 pages. It might take you 18 hours to read 18 pages. But go ahead and review this information in your leisure. We're trying to keep this quick. Since I'm promoting the software for My Attorney Home and Business, which is a Rocket Lawyer attorney, software, hold no grudges against me, Rocket Lawyer, for also providing an article that was created in connection with foreclosure attorneys of NOLA. But, they're connected or affiliated with this site, All Law, which is also included in the description bar below. So feel free to check out this article, this blog article on your own at your leisure. Truth in Lending Act is a federal law that was created to ensure that consumers receive accurate information when they enter into credit transactions. TILA, Truth in Lending Act, covers most consumer credit loans, including mortgages, credit cards, and home equity loans, and was designed so that the disclosures given to consumers would be consistent and standardized. This law requires a creditor to disclose certain information in writing regarding the terms of a credit transaction. There are two main types of TILA violations that can provide relief to borrowers when a creditor does not adhere to the law: violations for damages and violations that allow rescission. Rescission is the remedy that may help if you're facing foreclosure, as you'll see below. All right. Now let's go ahead and just for clarification, this is a blog provided by a team of attorneys. All right. So they provide information to, and they're the type of attorneys that seek to defend consumers against corporate fraud. All right. So for those individuals who are distrusting towards lawyers, once again, I say, if you've ever gotten into some type of action that would require you to have a criminal defense lawyer, already you're going to be a little biased towards the use of an attorney. But attorneys can be used as consultants or consularies, right, in the assistance and in the preparation of your documents or your petitions. So, and that does not have to necessarily be done by someone who is a licensed attorney. If you have a certified paralegal or a civil legal assistant who happens to be a member to any state or federal bar associations, and they specialize in this form of jurisprudence, by all means, you might want to deal with them. All right. And pro bono, aka the free options, do exist, but sometimes they don't fight as hard as you might want them to. So you have to be very much competent and aware and informed of what it is that you're going for or seeking as relief for damages or injuries committed against you as a consumer. Now, I have to specify or also illustrate or highlight and just give a lot of importance to the fact that the Truth in Lending Act is a federal act. All right. In which case, any damages that are sought or any complaints or suits filed should be filed appropriately within a federal court. More than likely it's something to deal with the Consumer Financial Protection Bureau, the CFPB. Now, I did not include that information in this video. I've done CFPB information in credit dispute, credit dispute initiation videos, which you can happily scroll through the content and find. So understanding that you're going to be disputing using the Consumer Financial Protection Bureau, who is a watchdog agency for the consumer. Once again, the Consumer Financial Protection Bureau and agency is there to assist consumers and protect them against fraudulent corporate activity. So, moving right along, let's keep on with some of these federal regulations that we're being informed of. TILA lists a number of disclosures that must be provided to the borrower, and if the creditor does not do so, it will be liable to pay any paid damages in an amount equal to the sum of the following: any actual damages sustained by a person as a result of the failure, and statutory damages limited to twice the finance charge, limited to twice. So it's no longer 3 times the debt claimed, but twice the finance charge, but not less than $400 and not more than $4,000. So you're still dealing with if you are initiating a complaint and utilizing the Federal Trade Commission's watchdog agency, the Consumer Financial Protection Bureau, then hey, it's a federal case. There's your relief or remedy monetized, all right, your compensation, but this can be done. You may be able to file suit per violation, depending. Material violations are grounds for damages include, but are not limited to, improper disclosure of amount financed, finance charge, payment schedule, total of payments, annual percentage rate, and security interest disclosures. Under TILA, a creditor is considered strictly liable for any violations. The creditor is liable, not the debtor. If you are filing a complaint, or you're initiating a complaint, or you're initiating a dispute between yourself as a debtor and another organization as a creditor, then also recognize that the creditor is probably more than likely doing business in a different state than you reside. And there's also the matter of diversity of citizenship that might be applied. In regards to foreclosure actions, more than likely the amount in question may exceed $75,000. So if you're not sure which venue to file in, check out some of the old videos and look at the video regarding filing in the federal U.S. district courts, all right, in matters of controversy exceeding amounts of $75,000, all right? So let's get into some actual law, because we've seen twice a couple of 15 USC mentions, right? We see 15 USC 1640 A12, and we also see 15 USC 1635 A and AF, all right? So let's take a look at the Truth in Lending Act provided by Federal Trade Commission, protecting America's consumers. Once again, some of us may be distrusting of the government, but you're distrusting of certain portions of the government, because you're not fully informed of the system of checks and balances. And you, as either a citizen of the United States, or a foreign national of another nation engaging in commerce with the United States in any shape, form, or fashion, understand what laws and remedies and what actions or forms of remedy may be available to you if you've been injured or damaged. All right, Truth in Lending Act, titled 15 USC, subchapters 1601 through 1667 F as amended. All right, there's a link also provided to you in the description bar. All right, the Act, Title 1 of the Consumer Protection Act, authorizes the Commission to enforce compliance by most non-depository entities with a variety of statutory provisions. Among other requirements, the Act requires creditors who deal with consumers to make certain written disclosures concerning finance charges and related aspects of credit transactions, including disclosing an annual percentage rate, and comply with other mandates, and requires advertisements to include certain disclosures. The Act has been amended on numerous occasions, adding requirements for credit cards and open-ended credit. For mortgage credit, such as ability to repay standards, loan origination, anti-steering, appraisal independence, and mortgage servicing, and others. A number of laws amending and enforced under this act are listed separately. All right. So, you have a bunch of relief there. Let's take a look at some portions of the chapter, right? Consumer credit disclosure. Now, I'm showing this, and I'll just read the opening statement. Informed use of credit, all right? The Congress finds that economic stabilization would be enhanced and the competition among the various financial institutions and other firms engaged in the extension of credit, consumer credit, would be strengthened by the informed use of credit. The informed use of credit results from an awareness of the cost thereof by consumers. It is the purpose of this subchapter to assure a meaningful disclosure of credit terms so that the consumer will be able to compare more readily the various credit terms available to him and avoid the uninformed use of credit, and to protect the consumer against inaccurate and unfair credit billing and credit card practices. In terms of personal property leases, and it goes on. Once again, the preface or the introductory clauses of any document will essentially give you the foundational aspects of what you're reading, right? So read on, my friend, read on. Let's simplify this and speed you up in this process, okay? Individual or class action for damages, amount of reward, factors determining amount of award, except as otherwise provided in this section. Any creditor who fails to comply with any requirement imposed upon this part, including any requirement under section 1635 of this title, subsection F or G of section 1641, which one, what codes are we talking? 15 USC code 1640. We're still in the Consumer Protection Act, you know. We're talking with respect to any person is liable to such person in an amount equal to the sum of 1. Any actual damage sustained by such person as a result of the failure to I. In the case of an individual action, twice the amount of any finance charge in connection with the transaction. So the amount of the debt times 2. In the case of an individual action relating to a consumer lease under Part E of this subchapter, 25 per centum, that means percent, of the total amount of monthly payments under the lease, except that the liability under this subparagraph shall not be less than $200 nor greater than $2,000. So there's a restriction regarding certain actions, right? Meaning, like, in addition to the finance charge that you're seeking for relief, that's twice the original amount, you'll also get 25%, 25% of the total amount of monthly payments, as long as it's not less than $200 nor greater than $2,000. So if you're at 201 and 1999, and that's so interesting. If you're below $200, you can't file. If you're above $2,000, you can't file or ask for this charge based on the 25% of the total amount of monthly payments. I don't want to overread certain things because that may confuse you. So definitely continue to read through this section on your own. Moving on, in the case of an individual action relating to an open-end consumer credit plan that is not secured by real property or a dwelling, twice the amount of any finance charge in connection with the transaction, with a minimum of $500 and a maximum of $5,000, or such higher amount as may be appropriate in the case of an established pattern or practice of such failures. Meaning the entity or the business that engages in the practice of extending consumers' credit, yeah, that's, you know, they have a practice or they have a pattern of practicing failures, you know, hey, initiate your dispute. In the case of an individual action relating to a credit transaction not under an open-ended credit plan that is secured by real property or dwelling, not less than $400 or greater than $4,000, or, and it continues to go on. This is basically like how you can compile your schedule of fees. meaning like your schedule of fees for damages made against you as a consumer. This has nothing to do with your complexion of your skin. This has everything to do with the complexion, or rather the color of your money or your credit worthiness. So they do this type, corporations who usually commit these types of actions against consumers are committing these actions against consumers who are not, credit informed. They weren't credit informed. They didn't know they weren't strengthened by the informed use of credit. So let's get you guys, strengthened through informed use of credit. All right. Now, for individuals that may be facing a foreclosure, 15 USC subchapter 1635, right of rescission as to certain transactions. This may be your remedy. All right. A disclosure of obliger's right to rescind, except as otherwise provided in this section, in the case of any consumer credit transaction, including opening or increasing the credit limit for an open-end credit plan, in which a security interest, including any such interest arising by operation of law, is or will be retained or acquired in any property. So before, we were dealing with things that did not pertain to real estate or real property, meaning like land or a house, right? In this instance, we're talking about acquired in any property. So real property, like such as, which is used as the principal dwelling of the person to whom credit is extended. So even if you're doing business out of your home, you have a home-based business, and this is for my self-employed individuals sitting at their desktops on a regular basis, who are now starting to get hit for, for matters that are consumer credit transaction matters that are secured under the Truth in Lending Act. By all means, continue to do your Google Fu, your Google Kung Fu, and get informed on the use of credit, okay? And start using some business credit, for the expenses related to your home office. So that way you're not overextending yourself. Trust me, I know it's hard. I'm rebuilding an empire right now, all right? The empire already exists, all right? Not rebuilding. I'm doing renovations. That's a better word, right? Doing renovations. Continuing on, the obliger shall have the right to rescind the transaction until midnight of the third business day following the consummation of the transaction or the delivery of the information and rescission forms required under this section, together with the statement containing the material disclosures required under this subchapter, whichever is later, by notifying the creditor in accordance with regulations of the Bureau of his intention to do so. The creditor shall clearly and conspicuously disclose, in accordance with regulations of the Bureau, to any obliger in a transaction subject to this section, the rights of the obliger under this section. The creditor shall provide, in accordance with regulations of the Bureau, appropriate forms for the obliger to exercise his right to rescind any transaction subject to this section. Return of money or property following rescission. So we've already seen that there's a statute of limitations regarding the rescission of a signature. However, we see that this has to be disclosed. Now, if you review your information, if you're dealing with a foreclosure, you review your original deed or your original certificate of deed or your original certificate of trust or the original promissory note or an exact or certified copy of the original promissory note that is in your possession. More than likely, you do still have the original promissory note or deed or certificate of trust in your possession, all right? Because that's how that actually goes, but that's for another video, all right? If you review that document and you see that the rescission clause is not disclosed to you, you might want to utilize or initiate a communication between yourself and the quote-unquote creditor, whether they're the original creditor or the transferring or recipient of a transferred deed. You might want to check with them or check that agreement for any disclosures of rescission, because if that disclosure is not there, they're in violation to not fully disclosing your right to resign or rescind your signature. Because if you would have known that they would have committed whatever actions it is that they're committing against you, like not properly accelerating the loan or not giving you an opportunity to have your day in court in a federal court, you know, in a U.S. district court, because the case or your house is worth over the amount of $75,000, then by all means, initiate your dispute. And that's not me telling you to. That's just a strong recommendation that you do your due diligence and engage in the informed use of credit or the dispute of how a corporation is fraudulently engaging in business. All right, they have patterns of a failure to properly practice. All right, those are all violations. For every violation that you can name or cite, you can be paid, you know, the minimum or the maximum damages within those violations or within that law. Right. So in certain instances, anywhere from 200, essentially anything per violation, $200 to $5,000 per violation. And if there's any conspiracy involved, then you might want to, or civil rights or human rights violations that are applied, then you might want to review Title 18, United States Code of Law, subsections 241 through 248, as well as Title 42, USC, subchapter 1983. All right. Now, those are videos for another time. I've already taken up a lot of your energy. I appreciate you for it. Thank you for staying focused. Thank you for hearing out this information. This has been a free service, a free consultation, a free educational informational video on just how on laws pertaining to your particular case may go. And just to show you some of the perks and benefits of using software such as My Attorney Home and Business, let's go over here to the Choose Documents, and let's go ahead and scroll down to Family Planning, and you see that there are a number of documents there for you to utilize. But let's go ahead and go to Consumer Issues, because this, by all means, is a consumer credit issue. All right. So if you need to initiate a complaint, I would initiate a free form letter. All right. And if you need to do so, you may want to do it under the Freedom of Information Act. And there is also a Freedom of Information Act letter. So let me find that very quickly for you. Freedom of Information Act request form. So you may want to initiate your, to initiate your dispute. You don't even know what the fuck you're doing just yet. Get informed, all right, about how do they process these documents? Was the information that's needed for you to have an equal understanding or to have full disclosure of your contract or your agreement that is in dispute? Did they give you all that information? If they did not provide you all that information, and if it's not accessible within the federal registry, they are in violation of the Freedom of Information Act. Well, that's my opinion. I'm not a lawyer. That's just my perception of it. It appears as though it is a violation, and I would need a lawyer, not a lawyer, but a judge to clarify whether or not it is a violation of the Freedom of Information Act, which they would be liable by, they would be liable and subject to fines of $200 to $5,000 for the violation, right, of not providing that information to them. Then, if they don't provide that information, then as a consumer, go ahead and initiate a complaint letter to the Better Business Bureau or your state attorney general. Depending on what state you're in, you may have either Better Business Bureau representation or Attorney General's office representation. Either way, initiate the complaint. All right, like, and you may not want to go straight to the Better Business Bureau. Maybe you want to go to the company first and initiate your complaint there, and then initiate your complaint with the Better Business Bureau or Attorney General, because the Better Business Bureau or the Attorney General might say that before you can initiate a complaint with them, you have to exhaust all means of settlement or dispute resolution prior to initiating a complaint with the Better Business Bureau or the Attorney General, considering that those are the initiating steps to suit proceedings or civil suit proceedings, or in this case, since this is not a civil suit, into the suits or filings in the Consumer Financial Protection Bureau's or Federal Trade Commission's jurisdiction. All right. Your issue might also be a bankruptcy matter, like depending on like where you're at, or if you have the ability to discharge the debt that the crediting bank or organization or entity might be saying that they are entitled to as compensation for the property that you have either failed to, pay on. So that being said, I have nothing left to give. My darling, I can't get enough of your love, baby. Now, real quick, the cost of this software is $40 online. All right, the description is in the description bar below. But if you don't want to wait, go down to Office Depot, see if they have it at your local Office Depot. If they don't have it at your local Office Depot, hey, be glad you got out the house. You got to see some sights. You got a little exercise. You breathe some good air. Don't forget to drink some water. And then go online to Amazon and make your order. All right, make your purchase. It is an Amazon affiliates link. So once again, while this is a free consultation or a free review of the My Attorney software, home and business, I don't get paid by the creators of My Attorney Home and Business, my software. I don't get paid by them. I don't get any type of, I'm not in, there's no paid endorsements here. But if you click on a link and you purchase the software through Amazon affiliate link, I make a small commission, and you're helping to support me make my Lyft, trips back and forth to clients that are in need of the service. Once again, what service? Preparation of petitions that you need done. All right, I'll sit with you if you can't afford the software, but you can make like a donation of any size, by all means. Make your donation. If you can't make a donation and you really need this service performed, the service is available to you for free. Once again, service is available by donation. Workman is worthy of their hire, but for those situations where, hey, right now you're trying to get your money because they stealing it from you, let me know. Let's get you right. All right. Once again, Prince L with More Simple Like Trust Corp. Home, My Attorney Home and Business software is the software you should consider. Don't forget to like, share, comment, subscribe, and I'm out this piece.